The criminal trial for former police officer Derek Chauvin is currently underway. At the time of this recording, there is a live broadcast of witness testimony. And there are some things I can point out, but we'll have to wait until the end of the day for a full analysis, which we do have for yesterday. And I got to tell you, we have not yet seen the defense's witnesses, but in the murder trial for George Floyd, the prosecution is faltering over and over again, and their witnesses keep backfiring. I'm just going to say it. While many people are pointing out that perhaps the prosecution is just bad at their jobs, could it be that they're maybe throwing the match? They don't want Chauvin to go to jail. They know that many police officers will resign at a time when they are desperate to get more officers into Minneapolis PD. There's a big recruitment drive they're trying to do. And what would happen if Chauvin gets convicted after being trained or told to do certain things that he did? Many officers might actually end up leaving. So what's happening now is, for whatever reason, the witnesses being brought forward by the prosecution, by the state, somehow keep backing up the defense. Recently, we heard in today's trial, one of their star witnesses, this guy from LA who's a use of force trainer, who said that Chauvin used excessive force, went on to admit to the defense that Derek Chauvin was well within his rights to actually tase George Floyd. And he explained that his matrix, this matrix they have for use of force, George Floyd was actively resisting. Thus, Chauvin was allowed to use a neck restraint and even tase George Floyd. This is crazy. The use of force expert who's supposed to be there for the state basically said that Chauvin chose a lesser option. He could have used more force and actually backed up upon this. There's an analysis from Legal Insurrection, which is mind-blowing. Because if you watch the mainstream media, they're only giving you headlines about Derek Chauvin doing bad, about how the witnesses for the state are saying all of these things that he did wrong. I'll put it this way. Imagine you're watching a boxing match. You're half paying attention. You're not really watching. Maybe you're reading a book and the fight's on in the background. And you hear that commentator going, Fighter A lands a punch. Fighter A lands a punch. Wow. Fighter A keeps landing punches. In your mind, you're imagining Fighter A punching Fighter B over and over again. The problem is the commentator isn't telling you that for every one hit Fighter A gets in, Fighter B gets in 3. So when the fight ends, you're like, oh, Fighter A clearly won. Because all of the headlines, all the commentary said this was good for Fighter A. And then all of a sudden they call it Fighter B wins the match. This is what I think may happen with Derek Chauvin. The state's case is miserable. And I'm looking at other legal opinions where they're just like, look at this. Legal Insurrection says the prosecution is visibly shaken after cross-examination of MPD force and medical experts. But the mainstream press knows they will get more clicks if they feed you the line they think you want to hear. Now, I'll be honest with all of you. I think for us in independent media, there's an inverse relationship to this, that it's, if I came out and said everything was going bad for Chauvin, maybe people wouldn't click this. They could just read it in the mainstream press. But I think there's a reason why we're independent personalities and why people who come on to YouTube and social media look for the other view. Now, it's true. There have been excellent points made by the prosecution. The issue I'm bringing up is not that Derek Chauvin is innocent, not that he's likely going to be thrown into the slammer for 40 years. It's that the media isn't telling you the burden of proof is on the state. So each and every time the defense throws one tiny little twig into the spokes, it's enough to get an acquittal. But the media, MSNBC, these analysts on TV are acting as though the burden is on the defense to prove innocence when it's not. You got to see this. I mean, there's a video they played today where the defense said, it sounds like Floyd said he ate too many drugs. And people are saying, I didn't hear that. The witness said he didn't hear it. Doesn't matter. Reasonable doubt for the jury. The defense knows what they're doing. I got to read you some of this from Legal Insurrection. This is an amazing article giving you a different view from the mainstream media. And it's very important. And then I'll show you some of what was said today, which is just, in my opinion, shocking. Before we get started, head over to timcast.com, become a member to help support this show. But more importantly, go to youtube.com/timcastirl and subscribe. This is my podcast show where we have conversations. And we are going to have a guest tonight who is, I'll just put it this way. Come check out the show tonight at 8 p.m. We're going to be talking about police use of force, police tactics with a very prominent personality in this space. Also gun rights. You can go to timcast.com, become a member to help support this show, but also subscribe to youtube.com/timcastirl. We're about to break 1 million subs, so we could use your support. But don't forget, like, share, subscribe, hit that notification bell. We're going to have an amazing conversation later tonight. But for the time being, let's go through the analysis from Legal Insurrection. They say, Chauvin trial, day 7 wrap-up, a horrible day for the prosecution. The prosecution is visibly shaken after cross-examination of MPD force and medical experts. They say, today was a terrible, horrible, no good, very bad day for the prosecution to a degree that I haven't seen since the trial of George Zimmerman. I also want to stress this article is written by Andrew Branca, giving his legal expertise. If you have no more than an hour to watch the video of today's proceedings, then I urge you to spend 44 minutes watching the cross-examination of state witness Johnny Mercil, the state's use of force training expert, and 22 minutes watching the cross-examination of Nicole McKenzie, the state's medical care training expert. In both instances, the result can only be called a train wreck of a disaster for the prosecution. Indeed, after the judge dismissed Mercil from the witness stand, Prosecutor Schleider appeared visibly shaken and angry, and he ought to have, given the mauling his case just received. At one point, Mercil testified that he himself had personally kept a suspect physically restrained until EMS had arrived on scene. Behavior, which the state had been arguing for over a week, was misconduct on the part of Chauvin. I'm sorry, this is nuts. The state kept saying that as soon as George Floyd was calm and restrained, there was no point to continue the restraint. That's not true. And even their own witness was like, no, actually, that's not true. You do want to keep him restrained. Earlier, another use of force expert said, in agreement with the defense when asked, just because you have someone restrained and they're being calm or they're not moving does not mean you just get up, because you have to take all these other considerations into play. There's an MMA fighter who testified that Derek Chauvin was using a blood choke. Well, this MMA fighter may have just undercut the whole case, because in this testimony today, the defense pointed out the cops are holding this guy back. Wow. The narrative is now Derek Chauvin is on top of George Floyd, whether it was right or wrong, and people are screaming at him. And he sees the police holding back this crowd. What does that mean? Well, according to the expert today, basically, if you've got someone restrained and there's an angry crowd around you, you can't just let this person up in the event that the crowd comes in, violence breaks out. Everything has to be locked down to a much harsher degree. I got to say it again. This guy even wanted to say that the moment Derek Chauvin arrived, he could have just pulled out the taser and shocked George Floyd. And the defense then said, so by not doing that and instead restraining him, he was using lesser force. And the witness agreed. That was just my mind blowing. Imagine you're on the jury and they're like, Derek Chauvin actually used less force than he was permitted to use. What? The witness called it excessive force. Okay, I got to slow down. It's crazy. With the media constantly saying only one fighter is landing punches, what happens then if Derek Chauvin gets acquitted? And I think he may. I don't know for sure. I'm not a psychic. There's a lot more in this case. But we haven't even gotten to the defense's case yet. The defense's witness haven't even showed up. It's the state's witnesses for now. This dude gets acquitted. Everyone's going to be like, but I heard over and over again from the press that Chauvin was wrong. He was wrong. They're not telling you what the defense is saying. And so in the end, people will expect a guilty verdict and they won't get it. And they'll say, aha, this proves the system is broken. It's the media doing it. He goes on to say, even worse, not only did the cross-examination of McKenzie by the defense also go badly for prosecution, it went so badly that Nelson, the defense attorney, informed the court that he intended to recall McKenzie as a defense witness when he presented his case in chief. Wow. The state's witness, who is here to prove the case for the state that Chauvin should go to prison. It was so devastating to the prosecution. The defense said, we want that person to come back to testify again. That's just, wow, is this going bad? Bad for the state. There are two other witnesses today, neither of which went particularly badly for the state. Although in the case of one of them, I expect it was only because the prosecution was saved by the bell when the court recessed early in the day. That doesn't save the prosecution. That witness will be back tomorrow. And I anticipate that the defense is going to have a field day with him on cross-examination as well. I want to make sure I stress the narratives coming from the mainstream press are not wrong. It is true that today the witness said Chauvin used excessive force. Fact. They did say that is not an approved, that is not, the MPD doesn't train in that, or that is not an official restraint. But you see, the problem is, as Legal Insurrection points out, because the state is purposefully using out of context statements, the defense comes in, fills in that context, and immediately rebuts what the state has said, and it's bad. I'm going to skip over some of these other points and bring you just to the worst of the worst. They say state's witness MPD Lieutenant Johnny Mercil, use of force trainer. They say, interestingly, Mercil testified at the start that he was currently on medical leave. A prior state witness, police officer Sergeant Evans, who took over the Floyd scene from Sergeant Ploger, had also testified he was on leave. Maybe just a coincidence. In any case, when on a medical leave, Lieutenant Mercer works in the MPD training division in charge of use of force training and policy instruction. He was active in that capacity during the period preceding the Floyd events, during which Chauvin would have received his department's use of force training and policy instruction, which is what makes Mercil's testimony relevant. Mercil is also a genuine fan of Brazilian jiu-jitsu, saying that he had fallen in love with the sport. This was elicited on direct, led by Prosecutor Schleider, no doubt to buttress Mercil's credibility, as was the direct testimony of Mercil about the expertise in hand-to-hand force techniques as both a trainer and a street cop, and his mastery of MPD use of force policies. Little did Schleider know how Mercil's credibility would shortly boomerang on the prosecution. Schleider did his usual routine, where he portrayed use of force options as being cast in absolute and binary terms. If A, then B. If X, then Y. Any variance of this was either out of MPD policy or at least untrained by MPD, and hence a wrong act. Schleider made use of the MPD use of force continuum and presented it in the most childish and sterile context possible. If at this level of the continuum, officer can do this but not that, correct. Mercil dutifully answered in the affirmative. But if at that level of continuum, officer can do that but not this, again, yes. Basically, he was saying, if George Floyd is not resisting, you can't use a restraint. Correct. Or you can't use a, force to this degree. Correct. What they don't tell you is that if George Floyd was just resisting actively, you can maintain a level of force. That's true as well. The defense brings this up. They say, Schleider would also pose simplified and hypothetical scenarios only minimally representative of what occurred with Floyd and ask if the use of, say, a neck restraint in that hypothetical would be reasonable. Of course, the answer for Mercil, as intended, that narrow and specific question would be no, unreasonable. Missing from all of this direct, of course, was any context around the complex dynamics and circumstances that often surround a police use of force event. That Schleider wants to avoid any such discussion is understandable, because doing so provides an appearance for at least reasonableness, if not outright justification, for Chauvin's use of force decisions and conduct with respect to Floyd. Another common routine from Schleider, when doing direct on state's witnesses who have purported use of force expertise, is to show them the photo of Chauvin apparently, but perhaps not actually, kneeling on Floyd's neck and asking, is this an MPD-trained neck restraint? Invariably, the answer is in the negative. That makes for a good headline, but in fact, it's not very informative on the actual issues of the case. Why? Just because a technique may not be an MPD-trained technique does not make it outside of policy, does not mean that it was legally unjustified, and certainly does not mean it contributed to Floyd's death, which is what the trial is supposed to be about. Once again, Schleider touched on positional asphyxia. And once again, I feel obliged to note that this doesn't really help the state prove Chauvin's guilt beyond a reasonable doubt in the context of Floyd's ingestion of 3-fold fatal dose of fentanyl. He says, certainly, if I did, this is huge. Okay, I tweeted this. Listen to this carefully. The writer says, if I had to choose between two situations, one in which I was placed in a prone position while handcuffed for 10 minutes, and another in which I was forced to ingest a 3-fold fatal dose of fentanyl, I know which I'd pick, and quickly. There's simply no reasonable comparison between those two risks to life. I want to pause right now and show you a tweet from Will Chamberlain. Will, of course, is a lawyer. I don't believe his practice is criminal in any capacity, but he does understand certain issues of how the law works and courts work. Will says, wow, Chauvin's lawyer just played a short excerpt of George Floyd while being held on the ground screaming out, I ate too many drugs. This trial shouldn't be happening. Update, here's the video. Now, I want to point something out. In this video, the witness is asked, does it sound to you like George Floyd yelled, I ate too many drugs? The witness says, I can't hear it. And that's fair, because honestly, I would not say with 100% confidence that George Floyd did say that at all. I can kind of hear it, but there's something you need to understand about being influenced in terms of audio. If there's low quality audio, someone could tell you you're hearing Yanny when they're actually saying Laurel, which I'm sure you're familiar with that whole thing. Some people will just hear something different. And that's just the way it is. There have been numerous experiments where they show someone saying pa, as in Peter, but they show a mouth saying fa, and people hear fa. It's a weird thing how sound works. By asking someone, did you hear this? You are essentially setting up someone to look for that sound. However, Will Chamberlain brings up the important point. Someone responded saying, even if it's true, since when has consuming drugs been reason to kill someone? Will says, you don't understand the defense at all. Drug use isn't the justification. It undermines causation. Chauvin didn't cause Floyd's death, an overdose did. And Will then says, we aren't even to defense witnesses yet. This is going so badly for the prosecution. No, hands down. As I pointed out earlier, a lot of people in the media and a lot of leftists and activists keep saying things like, wow, the prosecution said this, the prosecution said this, the witness said this, that Chauvin wasn't supposed to do that, he wasn't trained to do it. You're talking about murder. Murder requires the intent to kill for second degree and the intent to cause harm for the third degree, and it requires negligence for manslaughter. How can you prove any of those things when the state's own witnesses are like, actually, Chauvin could have used more force? Man, that's the craziest thing. Check this out. Lou Regus says, this is from today. Now Nelson is going over what Chauvin knew as he arrived on the scene and then observing Floyd actively resisting. This is important. In the continuum for the use of force, there's passive resistance, and active aggression. According to the state's own witnesses, George Floyd was in a state of active resistance, using his legs to push and try and get out of the car. Active resistance. He then says, Steiger admits Chauvin would have been within his right to use a taser at that moment. I'm sorry, my friends. I'm just going to say it one more time. That was brutal. My jaw dropped when I heard that. The defense then said, so it sounds like Chauvin was within his right of using a shock device or taser, but instead decided to do a restraint instead and pull back because sometimes you need to de-escalate. He's now got the state's own witness admitting that Chauvin did not use excessive force. In fact, he used less force, which is incredible because this witness was saying that kneeling on Floyd was excessive and then admitted on cross-examination, actually, he could have used more force. My jaw dropped. Let me show you some of these articles. From Medical News Today, tasers can stop the heart and kill. From the ACLU, tasers no longer a non-lethal alternative for law enforcement from May 3rd, 2012. Tasers are not non-lethal. I don't even think they're less lethal. I think some departments have classified them as impact weapons, meaning they kill. Think about that for 2 seconds. The state's own witness today. Okay, so this is not Mercil. Mercil was the guy from yesterday. And we'll go back to that commentary and we'll read about what was going on because it was bad. But I want to just deviate right here to talk about today's witness. A use of force expert who does trainings straight up said he could have applied potentially lethal force to Chauvin as soon as he got there, and he did not. Reasonable doubt. Let me spell it out for you. Derek Chauvin, according to today's witness, was within his right to use potentially lethal force immediately and chose not to do it. That takes murder off the table, period. That's amazing. Murder required the intent to cause harm. Maybe murder 3 if they say, well, he didn't want to tase him because he didn't want him to die, but he did want to hurt him and then he died. Then you have the drug statement. Then you have Maurice Lester Hall, the friend of Floyd, pleading the fifth, saying he could be charged with third-degree murder over supplying drugs to George Floyd. I'm sorry, man. If the headlines aren't giving you the full picture, this is going to be bad because people are going to expect a conviction and it ain't coming. The ACLU wrote in 2012, they say, in theory, a taser is intended to serve as a non-lethal method of control for law enforcement officers when they need to physically restrain a dangerous person. But as new circulation study demonstrates, tasers cannot so simply be categorized as non-lethal. In addition, There are far too many instances in which officers have impulsively deployed tasers. The new evidence that tasers can cause cardiac arrest and death, coupled with the disturbing trend of officers using tasers in flagrantly unnecessary situations, makes it all the more troubling that states do not uniformly or consistently govern or regulate officers' use of tasers. This means that taser policies vary greatly between police departments, often leading to vague, outdated, and inaccurate guidelines that result in misunderstanding about the misuse of these allegedly non-lethal weapons. This is an old article from the ACLU. I'm showing this to you because while the police are allowed to use tasers, in this instance, Chauvin could have very well outright just tased George Floyd, and he didn't. He pulled back. There was no intent to kill the guy. Amazing. It's just, we haven't even gotten to the defense's witness yet, and already the prosecution's case has just fallen to shambles. Let's read now about the redirect of this Mercel, who is with the Minneapolis Police Department. They say, the direct of Mercel was really just more of Schleider. The Schleider show we've already seen with the other state witnesses, kind of checking the boxes, but not even all the boxes needed to support the state's narrative of guilt. And always by only exposing the jury to half the context, which is a dangerous ploy. Basing your narrative of guilt on only half the context is a dangerous ploy because, thank God, we enjoy an adversarial legal system. And that means the defense gets to pop right up and expose the jury to the other half of the context, the half consistent with the narrative of innocence. And in this case, they get to do so with your own witness. And that's precisely what happened with Mercel, and in a big, big way. Check this out. Nelson began by asking questions related to Mercel's time as a street cop, with a particular emphasis on the tendency of suspects being subject to arrest to come up with all kinds of nonsense about why they shouldn't be arrested. Dangerous job being a police officer, yes. Are people generally unhappy about being arrested? Very rarely are they happy, Mercel answered. Do suspects frequently engage in a wide variety of behaviors to avoid arrest, including fighting, arguing, making excuses? Yes, they do, answered Mercel. Indeed, when asked if he himself had ever disbelieved a suspect's claim of medical emergency as an apparent effort to avoid arrest, Mercel answered he personally had done so. All of this, of course, undercuts the part of the prosecution's narrative that is relying on Floyd's purported pleas and excuses about claustrophobia and anxiety and crying out for mama. Perhaps all of that is real, but a reasonable officer must also consider that maybe much of it is simply an effort to avoid arrest. The witness from today, who was not Mercel, this is the other gentleman, interestingly stated when asked, had there ever been someone you restrained that once you released the restraint began fighting you? And he said, yes. I mean, it's right there. Chauvin apparently is 5'9" and 140 pounds, according to the defense, or according to, I believe, this article, actually. George Floyd is 6'6", 220 or 230 pounds. This was also asked of these use of force experts. If someone is smaller and has someone restrained, doesn't it make sense that they would maintain that restraint out of fear that this person could overpower them and they still pose a risk? Yes. There's so much to go through, man. I'm so like excited, not in the sense that like a positive, but like just like amped up by what's going on because it's crazy. Wow. Just repeatedly, we see the state's witnesses coming back and saying, actually, yeah, that may have been justified. It's falling apart for the prosecution. Check this out. They say this. Nelson also once again put the use of pressure and body weight techniques in a favorable light. The state wants to present Chauvin's knee in a negative light, as deadly mechanical asphyxiation, or as a blood choke as attested to by MMA Williams. In fact, however, the use of pressure and body weight to restrain a suspect was adopted by the MPD because it was a lesser intensity of force than the prior practices of using strikes, even barehanded or with batons, or even with weighted gloves, to compel compliance. Mercel concurred. To take home, the take-home message for the jury is that Chauvin's knee, far from being a public execution in a public street, was a lesser force than would have otherwise been required. Now I want to slow down. Let's bring this together. Yesterday, the defense got the jury to hear from the state's own witnesses that using the knee was a lesser use of force. And today, he followed up with their next witness. Chauvin could have used his taser against a man who was actively resisting. Yes, but he chose to use a lesser force. And now the pieces come together. How are you going to convict a man of murder when the defense says to you, murder requires the intent to kill? Based on the fact that Chauvin used lesser force, that doesn't seem to be the case. He then says murder 3 requires the intent to cause harm. Certainly he could have used more force and chose not to. Murder 3 probably out. Negligence. I also think he's gonna get acquitted on manslaughter because that would require some kind of negligence that resulted in the death of George Floyd. But he could have used more force. That's the opposite of negligence. He was trying to do less to the man. This is nuts, man. And the defense hasn't even started. They say, Schleider has described use of force in a very static and binary way. Once a suspect stops resisting, the officer should immediately stop his use of force, period. But Nelson got Mercil to agree that if the suspect had been forcibly resisting the officer only moments before, that would be a factor weighing in favor of continuing to apply force even after apparent resistance had ceased. That is, it's not just what's happening in the moment that counts, but what happened prior to the moment as well. Schleider pulled the trigger again with the last witness of the day, Jody Steiger, from LAPD acting as an expert witness for the state, and I don't expect it to work out well there either. And as we now know, it did not. He goes on to mention additional factors that a reasonable officer would take into account in deciding how much force to apply and for how long included a disparity in size between the officer and the suspect. And as we know, the 6'6", 230-pound Floyd was substantially larger than the 5'9", 140-pound Chauvin, as well as the circumstance in which a suspect not only fought police, but fought multiple officers, exactly as Floyd did in this instance. In today's trial, in the day of today, the trial for today, the defense asked about whether or not the defense asked the witness, Jody Steiger, the LAPD guy, about Chauvin being called initially to a counterfeiting circumstance, low priority, and then told to don't worry about it, someone else is there. He was then later called back saying it's a priority 1. Flip your lights on and get there quick. He can hear from the dispatcher. There's scuffling, there's fighting. George Floyd is actively resisting. He arrives on scene and sees this very large man resisting these officers, using his feet to kick out of the car while saying he can't breathe. Chauvin then had to assess. He's actively resisting. What technique do I use? Taser. Probably the maximum appropriate force for the circumstance. No. I'm going to help them restrain the man and keep him on the ground. Meanwhile, he's surrounded by people screaming at him, and they try to make it seem like Chauvin should have known what these people were saying. How are you supposed to make out what people are saying when everyone's screaming at the same time and you've got a large, actively resisting man that you're trying to stop? I'm not saying Chauvin is innocent of any wrongdoing. What I'm saying outright is there is reasonable doubt. What I'm saying is the state is failing to prove its case, and maybe it's on purpose. That's a bit of a conspiracy theory, but I wouldn't be surprised if that turned out to be true. In the end, what matters is reasonable doubt. They go on to say, when asked if additional use of force factors included if the suspect was believed to be on drugs and whether being on drugs could give a suspect exceptionally great strength, Mercil agreed to both statements. When Chauvin arrived, he was informed, and this is according to the defense and agreed with by the witness, that Floyd appeared to be under the influence. So here's a guy, someone's on drugs, they're actively resisting, and they're large. So what did Chauvin do? He decided not to use his taser. This context is mind-blowing because if you knew this from the beginning, your view on what happened with the George Floyd incident would be very, very different. Now, I don't know if George Floyd actually said he ate too many drugs or too many pills or whatever, but the defense is doing a great job in bringing that up because, as we know from the judge himself back in September, it appeared Floyd put something on his tongue and swallowed it. Could it be that Floyd was in the middle of a drug deal with Maurice Lester Hall, who was pleading the fifth because he thinks he could be charged over supplying drugs to Floyd, which contributed to his death? Could it be that George Floyd ingested these drugs and then that was the principal factor in his death? Or at the very least, without the causation of death being solely on Chauvin, murder 2 is gone, period. Murder 2 requires the intent to murder someone in passion. I don't see how you prove that at that point. Murder 3, that's on Maurice Lester Hall, who's pleading the fifth. And manslaughter, they made it seem like this is the opposite of negligence. I'm not saying it's true. I'm not saying I agree with the defense. I'm saying from the perspective of just hearing the arguments, the defense has now laid out that it was the opposite of negligence, that Chauvin actually took precautionary measures to not cause excessive harm to George Floyd. This is nuts, man. Check this out. When asked if a carotid choke, or what MPD would refer to as an unconscious neck restraint, required both of the carotid arteries to be compressed, Mercil answered that it did. So much for the MMA expert. The MMA guy said it was a blood choke. If a police officer is facing active aggression, they're allowed to use what's called an unconscious neck restraint. That's where they they choke you until you pass out. They cut off the flow to your brain. Derek Chauvin didn't do that, as evidenced by the fact that for an extended period of time, Chauvin's knee on George Floyd's shoulder or neck or base of the neck, whatever you want to call it, did not result in the immediate cessation of resistance from George Floyd. Let me read. They say, when asked how quickly unconsciousness occurred when a carotid choke was placed, Mercil answered less than 10 seconds. Clearly, Floyd was not being subject to a carotid choke for the large majority of the 9 minutes or so Chauvin had his knee in place, and likely never during that period. When asked if Mercil trained officers that a suspect who had become unconscious could regain consciousness, get back into the fight, and perhaps even be more aggressive, Mercil responded that he did. This is, of course, is a rationale for Chauvin to maintain his knee across Floyd's back, even after Floyd lost consciousness. As noted above, Nelson also explored with Mercil whether there were circumstances in which it would be appropriate for an officer to maintain a neck restraint for a substantial period of time. Mercil said yes. This is the state witness, the state's case just blowing up in their faces. I'm just shocked by this. Well, no, maybe I shouldn't be. The state is at fault. The war on drugs is at fault. Throwing Chauvin in prison won't change any of that. So it's no surprise then that the state is doing a terrible job in actually trying to prosecute Chauvin, and activists are probably going to say it. I think many on the left will look at a video like this and say outright, nah, we get it. The state is not trying to prosecute Chauvin. They're trying to throw the case on purpose, but make it seem like they put up a fight. I'm not saying that's true, but the leftists will certainly say it. They say, the state's own use of force expert testified on cross-examination that he had personally engaged in the use of force conduct that the state had been using to demonize Chauvin as unlawful. That's not a good day for the state. Quite frankly, the state's like, look what he did. You can't do that, right? And the guy goes, oh, I mean, actually, we do that, and I did it. Just crazy. Wow. On the issue of providing timely medical care, an issue that the state pushes with particular energy, Nelson had Mercil agree that while MPD policy is to provide care as soon as possible, that must take into consideration the safety of the scene, and that the MPD policy actually requires that it first be safe for the officer to provide care before the officer has the duty to provide care. Indeed, factors such as whether a suspect has been just fighting with officers was huge in determining whether an officer could reasonably provide care, especially if that care would be chest compressions requiring the suspect to have their handcuffs removed. Mercil answered in the affirmative. Later on redirect, Schleider would attempt to diminish the damage of this bit of testimony by asking Mercil if bystanders merely taking video would constitute a reason to not provide care. And the answer, of course, was no. But that merely provided Nelson with the layup opportunity on recross to ask whether a mob shouting insults and outright threats would constitute such a reason. And that was conduct for the mob in this event. And the answer to that, of course, was yes. All right. The state tried saying, look, there's some people yelling. That's not reason to not provide care. And the guy goes, sure. And then defense says, in this particular instance, the people were shouting threats and being held back. And the witness goes, well, yeah, that's a good reason not to stop what you're doing. You're in a dangerous situation. In this regard, then, the people surrounding George Floyd and Chauvin screaming obscenities and yelling actually contributed to the death of George Floyd. In this context, I'm not saying it's true. I'm not saying I agree with anyone. I'm just telling you what the defense is saying. This is, wow. This is just so much more. If that all sounds bad enough for the prosecution, you ain't seen nothing yet. It was at this point that Nelson showed Mercil a series of photographs captured from the body-worn camera of Officer Lane. Now, this we know. I brought this up yesterday, that the witness said it appeared the leg was not on the neck at all, but on the shoulder blades. In other words, the use of the restraint can be justified not only to compel compliance of the suspect in the first place, but to ensure that the suspect maintains compliance moving forward, especially given the experience and concern that unconscious suspects can revive and be even more violent than they were prior, even if that restraint is being held in place for as long as 10 minutes. And that's not just for the safety of the officer, but also for the officer's partners, for bystanders, and even the suspect himself. Just devastating for the state's narrative, and all of it coming from the state's own MPD use of force expert. Look at this. It was after Nelson was done with Cross that Schleider attempted to salvage something from his train wreck for the prosecution by showing a still photo of the bystanders, pointing to some holding phones and asking if people taking videos was good enough reason to maintain a restraint. Mercil answered that video taking by bystanders was not sufficient reason. That's when on Cross, here's the grand slam, my friends, Nelson pulled up the exact same photo the prosecution had just used and pointed out in the picture MMA Williams was clearly being physically restrained from advancing on the officers by the arm of another bystander pulling him back? Would the threat of imminent physical violence from bystanders be a sufficient reason to maintain restraint on a suspect? If the crowd is shouting that they're going to slap you, or that you're a P word, that you're a bum, would that be sufficient to cause the officers to be alarmed about the prospect of imminent physical violence from the bystanders? The state's witness, Mercel, said yes. This is nuts. You read the mainstream press, they're telling you it's going bad for the defense. Well, they're not really. They're just giving you the framing. Police say Chauvin shouldn't have done it. Police say excessive force. Today's witness said it was excessive force what Chauvin did. That's an important factor, and consider it. The jury may as well, and Chauvin could be convicted. But the media doesn't run the headline that the defense got the witness to admit Chauvin used less force than he was legally allowed or by policy allowed. Without that context, it sounds like they're saying Chauvin was in the wrong. In the full context, Derek Chauvin chose a lesser use of force. That's it. I don't see how an acquittal could happen. I'm sorry. I don't think I can see a conviction. I just don't. It seems like acquittal is all but guaranteed. I could be wrong. I'm not an expert. I'm only reading what the legal experts are saying from both sides. The left is saying only the good stuff, though, and that worries me because I'm reading both. And what you need to understand is the burden is on the state, not the defense. If the state needs 99 clear points to prove Chauvin did this, the defense need only one reasonable doubt. I think we got that. I think the defense hasn't even started their case, brought in their witnesses. We're going to see closing arguments, and the defense is going to say, you heard from the state's own witnesses that Chauvin was entitled to use more force than he did, and he chose not to. Certainly that would suggest reasonable doubt as to whether or not there was an intent to murder. That seems ridiculous. To cause harm? Absolutely not. Or even negligence. If Chauvin chose to use the maximum force he could have, it would have been worse for George Floyd. The mere fact that Chauvin decided to use less force should be reasonable doubt for all of the charges. We'll sit back and we'll see. More is to come. The trial is not over. Maybe things will change. But I kind of doubt it. I don't think I'm right. I don't think I can see the future. So look, we'll see how it plays out. Chauvin may very well be convicted for a lot of reasons. The prosecution may come back out with some better arguments. It may actually happen. They do have good arguments. Don't forget it. Don't think it's just because I'm bringing up this, it's a slam dunk for Chauvin. It's not. I'll leave it there. Next segment's coming up tonight. YouTube.com/TimCastIRL. And we are going to have a prominent commentator, police expert, gun rights advocate, I believe, all those things. Well, I should probably save it for the actual conversation. But we're going to have a fairly prominent personality coming and talking to us about this stuff. It's going to be fun, interesting, and important. So make sure you subscribe at youtube.com/TimCastIRL. We will be live at 8 p.m. Thanks for hanging out, and we will see you all then.